Thank you, Greg. And we can move to the next slide. So welcome everybody. My name is Adriana Novoa. I'm part of the bargaining team for the union and also part of the grievance committee. And we call this meeting today to kind of let you know what we're doing. And particularly at this time in which a lot of people is very stressed for the changes that we are facing. So I like to introduce our agenda for today. We will have very short presentations by our members who will explain what we're doing. I will do a challenge about academic freedom. We have Joshua Raymond, who is from philosophy, who will explain how UFF defends us. Then we have Ed Mitchell, who we're very lucky to have on our team. And he is basically presenting the lawsuits that we have pending. Then Richard Manning, who is the chair of our bargaining team, will talk about PTR and tenure. And finally, we have the president of the union, Steve Lang, talk about our future. So that will be followed by questions and answers. We try to save most of the time for that. So as I said, we will have a small presentation. And I would like to start myself with presenting you an introduction, basically, which I think is the biggest challenge that we are facing right now. And Susie, can you move to the next slide? So we have basically been in the process of losing academic freedom. And I would like to mention to you briefly what Florida intends to do and why we have these laws that have been disrupting our teaching and obviously our understanding of what is our role in education. Florida believes, and this is the arguments that they had kept in courts, that we are just employees and we are not different from any state employee. And that in universities, what we have is not academic freedom, but state speech. So basically, their point is that the governor decides speech because he won the election. And he has the right to impose then a speech in the classroom, what should be said in the classroom, what are the things that we will not authorize to introduce in the classroom. The other point they claim is that expertise cannot trump the voice of Florida voters. Basically, the governor has that right because he was elected, and that's the will of the people. So if the next administration has different ideas, the next administration will also be able to change according to the results of the election. So that is the legal argument that moves to the challenges that we are facing. Susie, can move the other slide. So the things that we are facing now are two very powerful threats. The first one related to 266 is the content control. So basically, that is related with state speech, what we can say, what we can teach, and the things that will be banned from our classes. They tried with HB7. Now this has been, we won lawsuits to get an injunction, and these are appeals. I think even the governor will say that they will lose that challenge. So that's the reason we have 266. So 266, that's exactly the same things that HB7, but only with different ways. They cannot teach anymore the viewpoints, that ban the viewpoints, because that was the reason for the injunction. So what they did is to attack with the control of general education. So they replaced the viewpoints by control of its entire fields. So the entire fields that teach the banned viewpoints of HB7 are now banned from the gen ed. Like the first case is sociology, will come more. And the reason for that is that we have annual reviews of the whole gen ed curriculum. And I think we need to present it in July. And the board had the power to select what courses will approve or not. So this means that general core courses, which are the biggest part of the funding of departments, will be pressure to decide on issues of content and avoid those who they know, obviously, are under question by the state. And they have a very powerful enforcement, because if you don't if you don't do what you're told to do, obviously you will lose funding, which is not the interest of any university. So see the next one. And the other part of this law that is devastating is the fact that it's not only a control of over content, it's also control over faculty. So we have in this law a very new things that emphasize that we don't have tenure, because we have now PTR. We have a procedure by which the board has more control over faculty. They move also the process in which you hire and you work with personnel. That's obviously the president now, and the president has delegated through departments, but the next president might not do so. And the last one that has very much to do with what we do in the union is the decisions regarding faculty, including the areas of evaluation, promotions, tenure, discipline, or termination, might not be appealed beyond the level of a university president or designee. So basically, what we are facing is a plan to change the nature of higher education and the role of faculty in it. And with that, I finish my presentation, and I will move to our next speaker, who is Joshua Raymond. He is a professor of philosophy. And Josh, you can go ahead.
Okay, thank you, Adriana. My name is Joshua Raymond. I'm an associate professor of philosophy, and I'm the government relations representative for the UFF. I'd like to talk about how UFF defends us, specifically focusing on the contract and the kinds of protections that the contract allows us. We are the United Faculty of Florida, the chapter at USF, and so we are part of the larger United Faculty of Florida in the state of Florida, which is within the Florida Education Association. So we have the power, as long as we are certified as the union to represent the Faculty of Florida, to negotiate the collective bargaining agreement, which governs all of our rights at USF, and they include things such as tenure protections and the particular procedures that tenure involves, a due process, which is particularly important with regard to the enforcement of those requirements. That would include the grievance process internal to USF, and then the possibility of binding arbitration with a neutral arbitrator, which has been banned under certain new state provisions. We see that in PTR. It governs assignment disputes, governs annual review, the grievance procedure. Our contract is unique in the state in banning furloughs. This is a particularly useful provision, which was inserted a number of years ago by a member of the faculty at USF, and because during the pandemic, the administration, facing something like what they declared as a $36 million hole while they're building a $36 million building, decided that they wanted to furlough faculty. They weren't able to do so. So that one provision in the contract alone arguably paid for the entire lifetime of union dues of 1% per year for any faculty members who would have been furloughed under that provision. The UFF is responsible for negotiations with the trustees of USF, and which govern our pay and our working conditions. The stronger the union, the higher the union representation within USF, the higher the pay, the better the working conditions. Statistically, it's backed up. Simply to have unions in the state leads to 15% higher pay at institutions that are comparable, and within states that do have unions, those with unions in the same class make $11,000 more than faculty at non-unionized institutions. The higher the percentage of union members, likely the better the contracts that we get, the higher the pay raises. And we've seen that in a number of cases, such as at HCC in their previous negotiations. Very high percentage, so we need more people to join the union. And of course, we're facing what will be discussed of the decertification that will happen if we don't have 60% membership, and we currently have somewhere in the 30s. As well, we can talk about the protections within the contract, which include non-discrimination. All of these protections go away completely with no union contract. Academic freedom, which is particularly at issue in multiple state measures underway. Promotion and tenure, all of those protections go away with no contract. Reappointment and non-reappointment, layoff and reemployment, due process, intellectual property rights are covered by the contract and would go away to some degree without it. Conflicts of interest, outside activities. In each of these, the union represents us. So the union provides representation in disciplinary matters within the university, provides for 2 free consultations with lawyers concerning personal legal matters. It provides for $1 million $1 million in professional liability insurance in case you get sued and USF does not want to represent you, as has happened recently at USF. So that's all I have to say about how UFF defends us. Back to you, Adriana. Thank you.
Thank you very much, Josh. And again, we will present briefly about the issues that are discussed in the agenda. And please put if you have questions in the chat, and we will answer when we finish with our speakers. Our third speaker is Ed Mitchell, and as I said before, we are very grateful that he's helping us, and he's very experienced in terms of union matters, and he's advising us also for the bargaining. Ed, you are ready to start?
I am ready to start. Thank you, Adriana. Just to give you a little of my background, I became a UFF member on my first day of employment at Hillsborough Community College in 1988. I've served as a UFF senator, vice president of the bargaining council, first vice president statewide, and executive director up in Tallahassee. So I have a very strong interest in the legal issues that we have to go through. To give you some background on what's going on right now, we had a case in federal court. It was filed in the Northern District, which is in Gainesville, challenging Senate Bill 256. That's the one that banned payroll dues deductions for education unions only. It also required 60% membership for education unions only. And it also had required language that we had to put on union cards. All of this was only targeted at education unions. It specifically exempted police unions, fire unions, and correctional officers. So it was very discriminatory in who it did. Unfortunately, the federal judge was not persuaded by any of our arguments and said no harm done and dismissed our case. We had a second federal case, which was also going on, and we ended up with a judge that people felt was not going to be a very good ear on our case. And so that case was dismissed voluntarily by UFF and FEA. The only other case that we have currently going in court is we have a state court case, which is being heard by a judge up in Tallahassee in the circuit court. And that involves the United Faculty of Florida, New College of Florida versus the Board of Trustees and the BOG. And that particular case, so far, we've only had one hearing, and that was a motion to dismiss by the BOG and the BOT. The BOT motion to dismiss was denied, and the BOG is still pending. And basically, what both were saying is that they weren't the employer, which is nonsense. Clearly, the BOT was, They also tried to argue that the contract wasn't valid because of the date or something. But anyway, we knocked that down. So the big question now is, what are the other issues we're going to raise in that? Because that's where we're challenging Senate Bill 266, which is the arbitration ban and PTR. So we have 0 federal cases going on right now, and we only have the 1 state court case in Tallahassee. However, in front of the Public Employee Relations Commission, called PERC, we have what we call unfair labor practice, which is when the union charges that the employer did something that violates either the law or a PERC decision previous to that. So we have 3 cases that are going on right now. We have 1 case involving the University of Central Florida. In that particular case, they already conducted their evidentiary hearing, and the hearing officer, who is what's called an administrative law judge, who is an employee of PERC. So they're appointed by PERC, and obviously all appointees are basically political appointees. So that hearing officer heard the case at UCF and issued what's called a hearing officer's recommended order. So at this point, that was done this past a week ago. At this point, both sides have 15 days to file exceptions to that. And hopefully, UFF, FEA, AFT attorneys will file strong exceptions to some of the conclusions that were made in that case. And if you want to see the hearing officer's recommended order, you can go to the PERC website and look it up, or you could send an email message to me or any of the other officers. They all have it, and we would be happy to send that to you. We have a USF ULP pending. We had 2 faculty members at USF. Both had been here for more than 10 years that were terminated when their program was, a language program was terminated, and they were not offered the protections under the contract, which both of them were entitled to 1 year's notice and an opportunity to look for other employment within the university. Not only did the university not comply with the contract, but because they don't feel that they have to go to arbitration, they basically said, we're not going to do that either. So both of those issues are pending in front of that. We also have an FSU case, again, challenging 266, all the same issues. That case was already heard by the hearing officer, so we're now waiting to see the hearing officer's recommended order. So moving forward, what do we need from the affiliates? In other words, what do we need from UFF in Tallahassee, the FEA, the NEA, and the AFT, all of the organizations that you have paid literally millions and millions of dollars in dues to? And what we need at this point is an aggressive defense of not only union rights, but faculty rights. I don't know how many of you were around 20 some years ago when Betty Castor was president and decided to retire. We had a senator from St. Petersburg who decided he wanted to be the next USF president. At that time, the SUS was governed by what was called the Board of Regents. The Board of Regents didn't even interview him for the job. So he got pissed off and he went back to the legislature and he got his buddies to abolish the Board of Regents. So without a Board of Regents, the question was, who governs the state university system? So we basically went through a period of what I call chaos, where there was power grabs and everything else going on. But what it impacted us is immediately all the universities declared that our contract, our CBA, our collective bargaining agreement was null and void, because they said that USF was no longer the successor employer to USF under the Board of Regents. Despite the fact that there's 50 years of case law clearly establishing that. So we had to fight that. We fought that in the courts. We fought that in front of PERC. We did statement of interest cards. We got 90% of the faculty at USF to sign one, and we got the BOT to voluntarily recognize that UFF, USF was still around and we still had a contract. That's where we are again. So we're back to where we started. And what do we need? We need to litigate, litigate, litigate. Okay, the first step of that litigation is when we, as a result of the breakup of the Board of Regents and all the chaos that ensued, Bob Graham, our former governor and US Senator, put forth an amendment to the Florida Constitution that created the Board of Governors. That amendment not only created the Board of Governors, but it divested the legislature of their powers over the state university system, with the exception of the power of the purse, the ability to appropriate funds. That's it. We've had at least 2 cases that have gone to the Florida Supreme Court that reaffirm that the SUS is governed by the BOG and not by the legislature. Unfortunately, apparently nobody has bothered to read that in Tallahassee, and we end up with the legislature thinking that they're in charge again. And so 266, the arbitration ban and the imposition of PTR are clearly violations of the Florida Constitution, and we need UFF, FEA, NEFT, and NEA to aggressively litigate that. We also need to challenge the BOG's authority over the SUS bargaining. In particular, when the Board of Governors was created, one of the first things that they did was establish what are the powers of the boards of trustees. In PERC, you have to establish who is the employer. So the BOG decided that all of the state university boards of trustees would be designated the employer for PERC purposes. That means we bargain our contract between the BOT and UFF, not the UFF and the BOG or anybody else. So we need to challenge the BOG's authority to, again, promulgate a rule that mandated PDR and abolished arbitration. The third item on the litigation scale there is that we need to challenge the state university system's BOT, in our case, the USF BOT, in mandating PTR and the arbitration ban. PTR is clearly an evaluation system. PERC has held that evaluation systems are what's called a mandatory subject of bargaining, which means that the BOT has to sit down at the bargaining table and bargain with UFF, the sole bargaining agent for the faculty, and come to an agreement. They can't simply impose it, which is what they did. Their argument at the ULP hearings has been, we're only following orders. But if you follow the logic that the legislature lacks the authority to impose and mandate PTR, and that the BOG lacks the authority to do that, then clearly the boards of trustees have violated law in Florida and our collective bargaining agreement. So we need to push. If you're a UFF senator and you're going to the meetings starting tomorrow and Saturday, you need to ask these questions and ask what's going on, who is litigating, where are these cases, because if we don't fight for our rights, we won't have these rights. I look forward to your Q&A when we get to that point.
Thank you, Ed. Our next speaker is Richard Manning. He is a professor in the philosophy department, and he will explain issues related with PTR, tenure, and the bargaining process.
Thank you, Susie, for putting that up there. Hi, everybody. Richard Manning, Associate Professor in Philosophy. I'm also the co-chair of the bargaining committee for the USF chapter of UFF. I'm a UFF senator, and I'm also an executive member of the executive committee of the faculty senate. So what I want to do is I want to give a little presentation so that you all, if you don't know, which many of you probably do, know exactly what the difference between tenure as we had it and tenure as post-tenure review would have us have, what exactly that difference is, as a way not only of letting you know what is what's happening to your rights, but also as a way of illustrating the difference between what you get if you have collective bargaining and what you get if you don't, or matters of importance to you are imposed by the other side. So if we can go to the next slide. Please, thanks. Okay, here's what tenure and post-tenure valuation look like when they're secured through a contract bargained by this chapter of the union. Article 15.9 defines tenure in this way. Tenure guarantees annual reappointment for the academic year until voluntary resignation, retirement, removal for just cause in accordance with the provisions of the article regarding disciplinary action, job abandonment, or layoff, etc. Okay, so what's just cause? That's defined in Article 16. Just cause is incompetence or misconduct. Any discipline, including termination for a finding of incompetence or misconduct, is subject to the grievance process outlined in the CBA, which terminates, according to the CBA, in arbitration by a neutral arbiter. Next slide, please. Now, you may not have known this. It may surprise some of you. The CBA already has post-tenure review. It's called sustained performance evaluation. It holds, or it provides, that every 8 years post-tenure, you'll be evaluated. Only faculty employees are allowed to develop the applicable procedures. So administrators and the like are not the ones who say how sustained performance evaluation is run on the agreement that we negotiated with the university. Moreover, peer participation, that means other faculty employees, peer participation is required at every level of the process. The only basis for the sustained performance evaluation is employee annual evaluations. Okay? And employees who receive satisfactory annual evaluations will not receive lower than satisfactory sustained performance evaluation. So if you've been being told that your work is satisfactory over the past whatever 8 years in your annual evaluations, you're fine. They can't give you a disciplinary finding of any sort. And moreover, employees who feel the process has been improperly conducted can grieve and ultimately, again, be heard by a neutral arbitrator. So that's what tenure means and what post-tenure review looks like when the USF chapter bargains to get to establish your rights. So all of that and a great deal more in the collective bargaining agreement protects both job security, but also academic freedom. And in particular, the collective bargaining agreement protects faculty from discipline or termination on political or personal grounds, or because their area of research and teaching is no longer viewed as worthwhile by the university. Okay, now, here's what it looks like when tenure and post-tenure are imposed by the legislature, the Board of Governors, the Board of Trustees, and the university administration. Now, every faculty member is to go through a review process each 5 years after last promotion or review. You need to compile a packet, which is very much like a tenure file, although it does not include outside letters of evaluation from experts in your field, so you can't get experts to support your claims that your work is good, et cetera, et cetera. And moreover, criteria of evaluation go beyond the areas in your assignment that are subject of annual evaluation. So it's not just research, teaching, and service. It also includes, are you conforming with state law, including state laws that control academic speech? Do you have a good history of professional conduct? Itself undefined. What's that? And other relevant measures of faculty conduct. Looks like you could put a whole lot of things in there, and it's ill-defined. Now, there are 4 possible outcomes in terms of ranks that you can be given, ratings you can be given in PTR. 2 of the 4 of them result in discipline. One of those results in immediate termination, right? You're done, but you do have a 1-year non-renewal period to not be broke, okay? The other results in the issuance of a performance improvement plan, which gives you at most 1 year to shape up. And if you don't, then you're done. And we all know what it's like trying to publish a year's time frame to, for example, get a research program, get some more publications. That is, in many fields, that's completely unreasonable. Okay. Of course, satisfactory or even outstanding annual evaluations don't guarantee you will not get one of these disciplinary ratings on your PTR. The chief academic officer, that's the provost or a designee of the provost, issues the final binding ranking or rating. And this is not controlled by previous ratings of the chair or of the dean. The provost can modify, reverse, whatever, okay? Final decisions may be appealed, including under the provisions of the CBA, if applicable, but now remember, the legislature has eliminated arbitration for these sorts of matters, or is trying to. So for that reason, the decision whether the university violated its own regulation in a PTR determination rests with the university. Hey, university, did you violate your process in firing me? No. What are they going to say? Okay. So next slide, please. Before I get onto this slide, look, it's the mark of tenure that whether you earn it or not is up to the chief academic officer. That's always been the case with tenure decisions. But once you have it, whether you keep it or not, whether you keep it is not up to the chief academic officer, short of a sustainable showing of just cause. So I think every one of us who's tenured or on a tenure track, and I know that we're not all tenure track employees, and I'm telling you these things as an illustration of the difference between what you get when you bargain and what you get when you don't, right? Every one of us who's tenured or on a tenure track, right? We don't have tenure. It's just a lie that we have tenure. Okay, people who are on a tenure track have lost the opportunity to get tenure. They're getting something else instead. Those of us who have who earned tenure, we don't have it anymore. All right. So what about grieving post-tenure review? Unlike sustained performance evaluation, at this time, post-tenure review is not a part of the CBA that regulates your terms of employment. And for that reason, we cannot file grievances to enforce PTR. That is to say, to make sure that PTR has been followed properly. However, as the imposition of PTR itself violates the CBA in a wide variety of ways, including altering your assignments without your written consent, right? We can grieve certain actions taken in the course of implementing PTR. So you can't come to us and say, I want to grieve this because they didn't do what they said they were going to do in post-tenure review. That we can't do. But if you come and say, I want to grieve this because I shouldn't, right? Because I had to do a whole lot of work to put together my post-tenure review packet and it's not reflected in my assignment, so they altered my assignment without my consent, then that's grievable. At least it's up for the grievance committee to determine whether that is a grievance worth following up on. Okay, for this reason, and also because there's going to be a lot of cleanup to do if and when PTR is struck down as unconstitutional, which I firmly believe it is, we advise you, document everything you do in the course of complying with the PTR implementation. Don't rob yourself of the kind of record that you may need to use in support of a grievance. Okay, next slide, please. So we are fighting post-tenure review and the abortion ban and a lot of other stuff at PERC and in the courts. For the rest of bargaining, we're fully prepared to listen to any administration proposals, and we will respond to these in the best interest of all our faculty tenure stream, and other, in a process that we aim to make as open and transparent as possible, and in which we plan to solicit broad input about what is important to you. We're also in the process of generating bargaining proposals of our own, again, based on faculty input and with the interests of faculty in mind. But, and here's the payoff and the ask, we can't do any of this if we don't exist. If we're decertified, you lose your right to collective bargaining, and you are on your own in trying to secure and enforce rights.
I'll be right back. Is it okay if I play this?
No, it's fine. I won't be here for much long anyway.
If we are decertified, you're on your own, trying to secure and enforce rights as an employee. And as the administration's complete refusal to resist post-tenure review, for example, and the arbitration ban in any serious way suggests, you're not going to do too well on your own anyway. Good luck with that. So sign the statement of interest cards and join the union. Okay, thanks.
Adriana, you're muted. Adriana, unmute.
Yeah. I couldn't find the the right place. The last presenter today is the president of our union, Steve Lang, who had been fighting for our rights since he was elected for this position. And he has been very helpful in the conversations, both with the politicians that decide this process, and also in educating the board. So Steve, you can start your presentation.
I'm just going to fill in a few things so that you can get to any questions you have for any of the speakers. Thank you very much for putting this together, Adriana and Susie, and thanks for all the people who have done all this work to put the basics together. Where we are right this very second and what's our current need, urgent need to move forward. First off, legally, it is true that we have challenged with an unfair labor practice. Ed is correct. There are 3 of them that are out there. Our hearing is coming up soon. I will actually be meeting with the lawyers this afternoon. The 2 plaintiffs that are named representing our chapter are myself and Karen Brumsberger, who is our grievance chair. And we will be going forward on that to some kind of a hearing. I have heard from the other chapter presidents that there are a total of 6 different ULPs filed, almost all of them over PTR and arbitration, that are in the pipeline. We were the second one filed, but we will be the 3rd one to go to a hearing. And our contracts are all slightly different from each other. And we feel like our contract is one of the strongest ones to go to the ULP, because of our 1.2 in the article that says that the university will not have any regulations, rules, or policies that violate this contract without bargaining them. So you can read 1.2a if you'd like to yourself. Now, that leaves us, though, with an urgent issue, which Richard alluded to, which is quite important. In order to do some union busting, the legislature passed in this last round this need to recertify all of your chapters. This is the first time that we've had to certify our representation of chapters since the days of Jeb Bush and moving to the Board of Governors. And there are 2 ways to do that. One of them you probably have seen or gotten in your mailboxes or had something in your box at home, and that is what we call the SOI, or Statement of Interest cards. Basically, to be just blunt, an SOI or statement card is a petition. You sign 2 of them, we keep a copy, and we give a copy to the state. You have to do that by your original certification date, and our certification date is coming up, I think, in March. It's either March 8th or 9th. And at that time, we will turn those in. And then when the cards are sent in, there are 2 choices. One of the choices is for the state of Florida to mail all the faculty an election where they vote to be represented by a union, or the other possibility, which did happen once in the past, is that the Board of Trustees looks at all the hundreds and thousands of cards that they've got, and they say, we're just going to recognize the union as bargaining this contract without bothering to go through the election. That's a possibility that they could do. So we need to have as many of the SOI cards as possible. It'd be really great if we had 80 and 90%. The second way you can certify your chapter is the membership. The exact number of people in the membership was set by the legislature. Again, we've challenged all these things as unconstitutional. We don't know what some court or PERC might rule, but the current law is that they want us to have 60% of the members of the in-unit faculty, because we have a lot of people who are not in unit, as members of the chapter. And again, that's actually the easiest and best way for us to show our power to the Board of Trustees and Board of Governors, and that is for everybody to simply sign up to be a member. And then as that membership grows, then we will achieve certification without even having to do the petition election. So that's kind of where our urgency is right now. Our urgency is in the next month, well, actually several weeks, if possible. If you have not signed cards, then please sign them and turn them in or mail them back. And if you have not joined with e-dues, then we would like for you to do that. We had I think we had 175 faculty who were active members having dues deductions who never bothered to switch over to e-dues. 175. That's a huge number of members who've been members of the chapter paying dues for a long time who just did not sign up and do the e-dues. Pretty simple thing to do. It works very well. I've been doing it for a year, and if people are not in the e-dues, then please sign up. And that's a really good thing too. I think e-dues was a great decision because the university does not know you're a member. We filed an unfair labor practice 3 years ago because our university, University of South Florida, would give a list of the names of the union members to non-union people. So they could take your name as a union member and give it to the Proud Boys or whatever you want, you know. And we filed an unfair labor practice over that, which we did not win. But at this time, because of e-dues, the universities and the university system would not even know who the members are unless we told them. They would not, and we would not. So they won't even know who's a member and who's not. On our continuing legal challenges, we have that one challenge that we're going to talk with lawyers about this afternoon. We fully intend to revive that lawsuit that was withdrawn because of the particular court it was going to. We'd like to revive that. We are challenging both the PTR and the loss of due process. And we would really, really like to get more of the other institutions in our area involved. So that's the short answer to our urgency for right now, is to get the SOI cards and to get the membership dues in and get the e-dues going. We have other plans and things that you've heard about, a lot about some of those, but that's the basics. So I think maybe we'll stop and answer some questions specifically for all of our panelists if we can.
Okay, Greg, Greg, please stop the recording.
Okay, so, where are you?
Should be on the bottom.